Happy 4th of July weekend. I hope everyone is doing well. My name is Mark Silver, and I've had the opportunity to present countless CLEs to tens of thousands of lawyers throughout the United States over many years, primarily through individual providers. And what I decided to do a few weeks ago was have these programs available for free for all attorneys in the United States. I specialize in criminal immigration and civil litigation consultation forensics. I basically am a forensic psychiatric social worker with doctorate in psychology. I'm also a lawyer. I have a background in political science, family systems therapy. And it's my job to evaluate individuals, to understand their history, psychosocial background, to humanize the case in an effort to allow the lawyer and the adjudicator, the court system, whoever it is, to also better understand the client, to understand that the client at some point in his life may have suffered trauma, challenges, and it may have impacted the individual's decision-making and judgment, either in childhood or in adulthood. I've consulted and evaluated well over 3,000 cases and had phone consultations for many, many, many others. For criminal lawyers, I've done countless consultations, but most of them are private cases, although about half are also CJA cases. And my work for criminal defense lawyers as a criminal mitigation expert is really in two areas. Criminal mitigation focuses now not just on pre-sentence evaluation reports, but also for pre-plea. At one time, criminal defense lawyers would focus on pre-sentence, obviously as a means to obtain a better outcome with the judge, but it's become clear that criminal mitigation is really something that has to start very early, almost the moment that the client first enters the lawyer's office when mitigation needs to be considered, because there are all sorts of issues and biases and prejudices that the prosecutor's office may have, and it's important to tackle those and to disabuse the prosecutor at a very early stage of issues that are related to the client. And that's what I'm going to talk about today in this first program called Criminal Mitigation, Rethinking Pre-Sentence Strategies. My office is in New York. I've been working here for over 20 years. And as I said, I've provided this as a official CLE for a number of providers, but I really want this material to be available for everyone. So the subtitle of my program is Humanizing the Client Towards a Better Legal Outcome. And as I said, the idea is to really understand that this is a human being who's in the courtroom, a human being who's gotten into trouble, and he may well have done something wrong, and perhaps this individual has a history of criminal wrongdoing. And, some of these clients have committed rather serious crimes that we're quite aware of. But justice can only be realized if we understand this individual as a human with individual failings, and that we tailor our understanding of what should happen to this person, both from the prosecutor's perspective and also from the judge's perspective for sentencing purposes, if we get a sense of who this person is and what kind of issues have brought them to where they are today. I have a couple books, but one in particular is called A Handbook of Mitigation in Criminal and Immigration Forensics. It's the 7th edition. I know some people have previously purchased other editions, but I have a number of chapters in there specifically with regard to how to evaluate these kinds of cases, challenges that criminal defense lawyers may have. I have another book called Psychosocial Evaluations and Consultation, which very clearly outlines how psychosocial evaluations are undertaken. I have in my YouTube box, you can see my webpage. If you go there, you can see the books I've written and the work I've done to give you a sense of my clinical orientation and what my priorities are as an expert. I really try to integrate theory with practice, and as a result, please don't hesitate to email me and put in the subject line complex trauma or criminal mitigation, something so I know it's not spam. Please, in the email, put your full name, address, all your information. I promise you I won't send you spam. I just want to make sure you're a real attorney. And I'll send you back a redacted pre-sentence criminal mitigation report that I think integrates many of the things that I talk about in this program and in future programs for criminal defense lawyers. And I hope to put up 3, 4, 5 on the web, as I did for immigration lawyers, and as I'm going to do for civil litigation lawyers. But again, it's to integrate theory with practice. It's not just so you can see my CLEs or this program on YouTube, but to really understand how the theoretical aspects of forensic evaluations for criminal defense lawyers become something that's of practical use. And that's the bottom line here. I want the criminal defense lawyer to be able to use the consultation that he or she has with me and the reports that I write in a practical way. I want our work to complement and to balance one another to the benefit of the client. I want the criminal defense lawyer to have a better tool to understand the client's background, his decision making, so that the attorney can become a better advocate for the client. I'm going to do, as I said, a series of programs. I won't go into all of them in detail. I hope to do one on pre-sentence investigation reports by the probation officer, white-collar crime. I've done quite a number of sex crime and porn cases, which we'll talk about. I'm going to be presenting a specific program on complex trauma because it's so important for criminal defense lawyers to know about. I'm going to do a program specifically on borderline personality disorder. It's probably the single most important disorder that is generally neglected in the criminal justice system. The Adam Walsh Act I've done in the context of criminal defense work, even though it's a criminal mitigation case, and you're certainly welcome to look at my YouTube video for that. I really stress that because, again, the criminal mitigation part of the Adam Walsh Act for immigration defense lawyers really reflects a well thought out strategy about how to tackle criteria in a particular case and some of the biases that would accompany it. I've also written out and hope to present some other YouTube videos, including on domestic violence and so on. So the first thing I'd say is that, mitigation is not something that's magic. Criminal mitigation is a tool. It's not an end in itself. And the lawyer has to use the mitigation report and the mitigation expert as a tool and to better holistically and fully understand and advocate for their client. As I said, the goal here is for the mitigation expert and the lawyer to complement one another's expertise. They should balance one another's abilities. My goal here is to assist the lawyer. One of the things I really realized in law school was that there's no course on how to evaluate a client, whether it's for criminal defense case or a personal injury case, a family or matrimonial divorce case. There are all sorts of cases where you need to know how to communicate with the client. You need to know how to ask questions and to elicit material and to gain their trust. In order to evaluate the case, you have to, in a sense, evaluate the client. And part of what I do, frankly, is exactly that. I evaluate the client not only for mental health issues and family issues and so on, but so that the lawyer can have a better sense of who the client is to fill in the gaps that may have been more challenging when the client was speaking with the lawyer about his or her particular issues. So I want to give first a general definition of criminal mitigation. Mitigation is a biopsychosocial evaluation of the client's social and psychological history informed by the facts of the criminal case, with appropriate recommendations as a means to minimize the negative legal outcome either in court or with a prosecutor. Mitigating circumstances reduces the degree of moral culpability or blame, which in fairness, sympathy, or mercy may lead to a more favorable outcome for the defendant. So we're looking at anything and everything in the client's history, and that's why these kinds of evaluations and these kinds of clinical programs are so important for the lawyer. We don't get these in law school. And honestly, I've been trying to advocate for many years for National Association of Criminal Defense Lawyers and a similar state programs for criminal defense lawyers to have these kinds of programs. National Association has done one or two, but to have all these programs available for criminal defense lawyers at both the state and the federal level. So we're looking at anything and everything in the person's background so that the prosecutor, so that the judge can identify with specific challenges and issues in this person's life and how they came to be in trouble because of their judgment and poor decision making, so that we end up with fairness and sympathy that could lead to a more favorable outcome for the defendant, obviously, but really, hopefully, a more just outcome in general as well. In my mind, there's been a huge shift in the criminal justice system. I'm sure other people realize it as well. When I was in law school, evidence was a core course, including for criminal practice. In a sense, it's not so important now because so few cases go to trial that evidence, in a sense, has become delegated to the basement, and the tripartite system of judge and prosecutor and criminal defense lawyer has been shifted to an empty courtroom where sometimes judges are twiddling their thumbs and prosecutors have become very, very powerful. It's really, I think, a system that in some ways is quite unfair now. Some people identify this as the trial penalty, which is that the penalty meaning that if the criminal defendant does go to trial, it's terribly expensive, it's terribly embarrassing, it's very time-consuming, and of course, most importantly, the sentence that would probably be available at the end of trial if the criminal defendant loses is going to be much more severe than the plea deal available to the criminal defendant through the prosecutor's office. But the trial penalty really has completely reformulated the system, in my opinion, and it makes criminal mitigation and advocacy for the client, explaining who the client is at a very early stage, absolutely essential. Criminal justice today is, for the most part, a system of pleas, not a system of trials. I'm quoting that from Lafleur versus Cooper, the 2012 case. Pleas can be coercive. There's pressure. Police and prosecutorial abuses that may regularly produce false convictions is a very serious concern. Plea bargains could lead to the police not acting as they should, even misconduct. And, the truth is, public scrutiny, I think, is simply not there. I don't think the public really realizes it. And I really see this in white-collar cases, and I've done a lot of them, where you have people who've never been involved in the criminal justice system before. They didn't have any problems as a child or adolescent or young adult, and they get arrested for something, often in their 30s, 40s, 50s, for the first time, and they just can't believe the challenges and the unjust issues connected to the criminal justice system. You sort of idealize the system when you're not in the system as being a great system and fair, compared to regimes and tyrannical governments in the world. We seem to be much more lucky, obviously, and we are. And yet, when you're caught in the thick of it for the first time, you realize just how frightening it can be and how oftentimes justice is not available. So really now, criminal mitigation is absolutely key and central. This is particularly true because of 18 U.S.C. 3661. As we all know, no limitation shall be placed on the information concerning the background, character, and conduct of a person convicted of an offense which a court of the United States may receive and consider for the purpose of imposing an appropriate sentence. I'll just give you some of my favorite law quotes. Excuse me. In deciding what sentence will be sufficient but not greater than necessary to further the goals of punishment, a sentencing judge must have a generosity of spirit, that compassion which causes one to know what it is like to be in trouble and in pain. That's Judge Danny Chin from the Second Circuit. Excuse me. Another quote, it has been uniform and constant in the federal judicial tradition for the sentencing judge to consider every convicted person as an individual, in every case as a unique study in the human failings that sometimes mitigate, sometimes magnify the crime and the punishment to ensue. That was Justice Kennedy. District courts should not hesitate to use their discretion in devising sentences that provide individualized justice. That's U.S. v. Williams. The guidelines do not require a judge to leave compassion and common sense at the door of the courtroom. It's another favorite quote that's from U.S. v. Johnson in the Second Circuit. Let's see what I have here. Imposing a sentence on a fellow human being is a formidable responsibility. It requires a court to consider with great care and sensitivity a large complex set of facts and factors. The notion that this complicated analysis, the moral responsibility, can be reduced to the mechanical adding up of a small set of numbers artificially assigned to a few arbitrary selected variables is variables with common sense is obviously extremely challenging and difficult. Whereas apples and oranges may have but a few salient qualities, human beings in their interactions with society are too complicated to be treated like commodities, and the attempt to do so can only lead to bizarre results. I sort of took parts of that quotes from U.S. v. Gupta. Just one more, and then I'll go into some more substantive issues, but I just think these quotes are meaningful. Surely, if every man is to receive credit for the good he has done, and his immediate conduct and his immediate misconduct assessed in the context of his overall life, it should be at the moment of his sentencing when his very future hangs in the balance. This elementary principle of weighing the good with the bad, which is basic to all great religions, moral philosophies, and systems of justice, was plainly part of what Congress had in mind when it directed the courts to consider as a necessary sentencing factor the history and characteristics of the defendant. That's from U.S. v. Adelson in the Southern District. One more, I promise. It's the last one. If the 600 plus pages of the most recent set of sentencing guidelines has taught us anything, it is that punishment cannot be reduced to an algorithm. And that's U.S. v. Myers. One thing that, I take this really from immigration court, where I've testified countless times, is that the judge wants to look at who is in the courtroom at this very moment through the mitigation. It's clear that wrongdoing has occurred, and hopefully the client presents with contrition and genuine remorse and regret. But the judge hopefully wants to be able to look at a person at this moment in time and be on the right team. In other words, to make a decision that's in everyone's interest, including the client's interest, including the criminal defendant's interest, as a means to improve things. Punishment is important, deterrence is very important, but there should be this idea that we try to advocate that not only is this about the individual client, but it's about a system that needs to have reliability and predictability, and that there has to be incremental improvement for this individual and for the system as a whole. Criminal mitigation is mandated by law in Wiggins v. Smith, the U.S. Supreme Court case from 2003, which found that a lawyer's failure to procure a psychosocial report explaining the troubled background of a defendant in a capital case was an error of counsel. I'm not going to go through the guidelines because honestly, I'm not an expert on that. I'm an expert on criminal mitigation as a forensic expert doing psychosocial evaluations. But it's important to understand that in the memorandum of law presented by the lawyer for sentencing purposes, it is crucial to interweave the criteria, the legal criteria from 3553A. It's important to interweave that material into key mitigation factors outlined in the mitigation report. This will truly afford the prosecutor and judge to consider and understand the client's psychosocial issues as legal mitigating factors rather than simply background information established for the sake of general argument. That is, criminal mitigation is not simply an effective tool for the sake of argument, but it's a necessary factual underpinning to the legal factors found in 18 U.S.C. Section 3553A and other relevant case law. One of the outcomes of all this is that the court now has unfettered discretion to consider any and all evidence, and a wide range of arguments may now be considered at sentencing, especially because of Booker. One thing that I've always wondered about this, we had, of course, the Supreme Court case in 1963, Gideon v. Wainwright, that mandated the constitutionality of having a criminal defense lawyer in felony cases. Should we, or is it necessary to have a similar program for criminal defendants for mitigation purposes, to consider by a professional psychiatric issues, family, community issues, a broad psychosocial background that elicit information that would not perhaps otherwise be uncovered by the criminal defense lawyer, who may know his or her client very well, and would certainly not be uncovered by the probation officer at the pre-sentence investigation. And as I said, I have a separate CLE on this, but one of the most disturbing things that we've come across over the years is simply how the PSI is so deficient in core areas, including psychiatric issues, family issues, and so on. It's also noteworthy that in 2012, the American Bar Association House of Delegates adopted Resolution 107C, which formally urges criminal defense attorneys to address clients' civil, legal, and non-legal problems to linkages with other service providers. The report accompanying the resolution makes it clear that all defense lawyers are required to provide comprehensive representation, including using other service providers like social workers when appropriate. And I guess one of the things that I'm arguing, this is the underlying issue, is that there's so much we learn about in law school, but one of the things we don't learn about is how to get help when we need it. And clearly in so many areas, including family law, immigration issues, and particularly criminal defense lawyers require criminal mitigation experts with clinical expertise in forensics to gain an understanding of who the client is for advocacy purpose. So what's the point of all this? What's the point of criminal mitigation? It's, as I said, to humanize the client through a sympathetic narrative, induce sympathy for the reader, document the client's life history, contextualizing the client's conduct, stress hardships and financial ties, physical, emotional, and other, illustrate the client's community, educational, employment ties, obviously express the client's remorse and regret. Very, very importantly, professional expression can replace self-expression, meaning that we always have and we always want criminal defendants to go to lawyers because the criminal defense system is counterintuitive, it's difficult, it's challenging. Similarly, the criminal defendant needs a criminal mitigation expert to express their own issues because they may not have the education to do so, they may not have the psychological wherewithal, they may be emotionally overwhelmed and at times even physically unable to cope. Criminal mitigation is very much focused on mental health, but it's not a mental health report. It encompasses a wide range of different issues in the person's psychosocial background, And in fact, there's something I call the single document theory, which is, criminal defense lawyers, and sometimes I see this with immigration as well, where they try to submit a large package of information on the client, and sometimes it's helpful for the judge or the prosecutor to have a much shorter, perhaps 20-page report that has summaries of some of these issues so that the prosecutor judge can better digest these matters in a single report. Of course, it can be a peace offering when there's a lot of contention between the prosecutor and criminal defense lawyer at times. It certainly does counter the government's pre-sentence report. And sometimes, I've had criminal defense lawyers call me, and I've done lots of consultations over the years without writing reports, where they call for a consult. They say, I have this client and I'm trying to understand the issues, his judgment, the person just seems to undermine their own best interests. They're jeopardizing the case. I've done my best. What can you do? Maybe you can interview the client even if it's only for an hour and speak to them and so on. And I have done those cases with some success. Perhaps the key issue, and I said this at the beginning, but I really need to repeat it, is to disabuse the parties of bias and false assumptions and prejudices. Dispel non-existent patterns of behavior that the prosecutor may think are there. Sometimes the prosecutor may have a lot of anger or hostility towards the client because he's done something that's considered unforgivable or terrible. I see this, quite frankly, in white-collar cases where the white-collar criminal defendant is demonized because it's thought that, well, here's a guy that's had every opportunity. He has a high school and college education, sometimes a second degree. He grew up in a good home, and he had a good job making a very high salary, and now he's committed fraud or whatnot, whatever it is, and this person really should not have mercy. And, one thing that I would say is that you don't know an individual unless you really know an individual. Someone may have grown up in what appears to be a white picket fence home, but you need to pick up that home and pull apart that white picket fence and look inside to really understand that client's experiences in childhood, adolescence, young adulthood, and so on. And you may find a very normal background, and that's challenging at times. And yet you may find someone who seems to have grown up in a very middle-class home in a safe and healthy community, and yet the individual indeed suffered very serious traumas. Some of the key ideas I try to consider in criminal mitigation is this an aberrant decision? Was it based on poor judgment? And that could be helpful in describing the flaws of the client. Is it misguided behavior? Did this reflect an error in judgment? In other words, sometimes I see clients that sort of just talk themselves into doing this. Is it foolish conduct? Is it a mistake? I see a lot of clients, and this is for white collar, where statutes are overly complicated and they don't understand it, and sometimes they get very defensive, actually, with their lawyers and with the court system because they're convinced they did nothing wrong. I see clients where they say, well, this is normal behavior for my colleagues, and that's just not in white collar cases. It's in other cases as well that I've seen, and therefore they find it hard to take responsibility for their wrongdoing. Many clients over the course of months and even years have experienced cumulative stressors, some of which can be quite serious. And the client may have had a diminished capacity and they did something in an unthinking moment. Diminished capacity is something that lawyers, criminal defense lawyers, very much associate with psychosis because the person has, they hear voices or they have delusions, they have beliefs that are not real, and they suffer from perhaps a diagnosed mental illness such as schizophrenia or bipolar disorder, that they have diminished capacity. But the truth is, for our purposes in criminal mitigation, we're looking for diminished capacity in a much broader sense. In other words, are there life stressors and issues that have, over the years, added up to really, cause this person to commit this error of judgment and misguide them? I've had cases of conscious avoidance where the client should have known better. That's a central idea to consider. And that can attach with genuine contrition at times. At the end of the day, we're trying to show, hopefully, redemption, what's called tshuva, that the person was honest with themselves about their wrongdoing, and that their inner transformation is real, and they've understand how their behavior, their way of thinking, even their emotional well-being affected them, and how it's contributed to their refocusing in a much more healthy way. Rehabilitation, redemption, transformation, these are key ideas, especially if the person enjoys community supports or strong social services or family love and care in the community. We don't want prison to interrupt a healthy pathway. That's a key idea. If many months or even years have gone by and the person has really redirected themselves, we don't want prison to get them on the wrong track again. Prison is a very unhealthy place, generally speaking. And if a person, especially if they have a very low history of criminal behavior and they seem to be doing well and they have a family they're taking care of and they're working consistently, they're part of their community, their behaviors reflect that they are a responsible individual and so on, we want that person to continue on that positive road because that'll also help reduce recidivism. It's very important to understand, Richard Posner in the Ninth Circuit is very well known for the rational player theory. In other words, this is a larger theory that, people make decisions based on their own rational self-interest. It's huge in economics, even psychology and so on, in law. The reasonable standards is very much based on this. But it's not true. People don't make rational decisions. People make emotional decisions. We make decisions based on how we feel about things and our psychological well-being. After we've made the decision, we then rationalize it. We then explain it to ourselves in a way that seems to make sense. But this is an important issue to consider, to understand what was the person thinking at the time of their wrongdoing. And I have this in one of my chapters of my book, but we're so focused in law school to think about intent, not just in criminal law, but in civil law as well. I always try to think of volition. Volition is a broader sense of one's decision-making and judgment, and it could really be very informative to help understand how this person made such a bad decision that got themselves into trouble. There are many other mitigation considerations. What did the client's past look like? What role did the client play in this crime versus his life in general? Will the client likely repeat this behavior? Will incarceration promote deterrence? What will promote justice and promote respect for the law in general? What will the client's experience be like in jail? Does the client require educational, vocational, medical, or psychiatric assistance? What kind of rehabilitation is necessary, and has it already started? Has the client accepted responsibility for his wrongdoing through genuine remorse and regret, and to what extent? Has restitution already started? Is it necessary? Is it even possible? Obviously, what is a fit punishment? Has the client already been punished? We see clients all the time that because of their wrongdoing, they have lost their home, their savings, sometimes their family. Their health has substantially deteriorated. Their employment and future employment may remain extremely uncertain. And some of these clients have already been very severely punished, which needs to be outlined. A huge question, of course, is what is the least harsh alternative? Are there alternatives to jail that would better serve the client, the family, or the community in jail? Who will be harmed by, or protected for that matter, by protracted incarceration? What are the family's needs? Is this an individual who has 2, 3, 4 children he needs to provide supports for? What will the client's future look like if he's incarcerated versus remaining outside, where an alternative sentence approach can be taken that allows him to stay on a healthy pathway. I have another chapter in my book on the 10 R's of mitigation, and I won't go through it because it's a little repetitive, but it's a very good structure to use to consider the criminal mitigation factors. When to use criminal mitigation, you know what they say in Chicago, vote early, vote often. It's never too early. Like I said at the outset, criminal mitigation at what time was thought to be most helpful for pre-sentence purposes. Clearly, criminal defense lawyers now understand that it's equally or more important for pre-plea purposes. One of the huge advantages is if you get a criminal mitigation report for pre-plea and it doesn't work out, you can use basically the exact same report for pre-sentence purposes. So you get two uses for one price, which is really cool. Mitigation has been used for parole, probation hearings, clemency. I haven't done any cases where I've written reports for clemency, but I've consulted on a number where criminal defense lawyers have called me and they say, this guy's been in jail for 15, 20 years. And what I recommend is looking at the case de novo. In almost every single case, there has not been a criminal mitigation report that was done earlier. And so looking at the case de novo in the sense that looking at anything and everything that helped explain this person's psychosocial background and what got them into trouble, and then having, in a sense, a completely different report, but obviously structured in the same way, that looks at this person's life in the last 15 or 20 years while incarcerated. Everything good the person has done, if they've been involved with jobs or social services, helping out in different ways, becoming educated. And certainly we want to emphasize if the person has shown positive behavior and not had infractions, which unfortunately are not uncommon in prison. I hate to say it again, but one of the key areas, frankly, then is to counter the PSR. And very often I get cases after the PSR has already been done. The advantage for me is I can read the PSR and see where there are holes. But you want the probation officer to be able to review the criminal mitigation report so they don't have any excuses when it comes to not knowing about traumas and psychosocial issues and whatever else issues that are almost always not properly documented or even fully omitted from the pre-sentence investigation. Who most benefits? Clearly, criminal defense clients who have mental health problems, those who have suffered extreme hardships, those who've encountered childhood traumas and abuses, those with interfamily dependence, clients with poor language, communication, social skills, those with poor adaptive or executive functioning skills, and I'm sure you've seen this 1,000 times, clients that just don't seem to be able to take care of themselves, clients that are not very educated and cannot self-advocate or explain their behaviors or even thoughts or even their feelings, clients who fear authority, clients who may be very guarded and suspicious and reluctant to even work with their criminal defense lawyer. And the other client who really benefits is a client who just needs a consult. The lawyer who says, I think I can handle this case. I don't need a criminal mitigation expert, but there are one or two things that the client's not willing to talk about, and I want to get a sense of strategy about which direction to go to. And so a formal criminal mitigation report may not be necessary, but rather a consult. Many clients have suffered mental health issues for years and even decades, and it's not well documented, and that's very necessary, core part of the criminal mitigation report. But the other end is also true. You see clients who really seem to be functioning, and they don't show signs of psychiatric issues. And that also needs to be documented and explained, because prosecutors are thinking, well, there's something wrong with this person. Why would he have committed this crime? And sometimes through a psychosocial narrative, you can get a sense of how someone came to get himself into trouble without labels, without psychiatric labels, without diagnostic labels. I have a book that specifically looks, as I said, on how to develop psychosocial evaluations, but you can understand almost anyone through a psychosocial evaluation, and it's a tragedy that, this isn't taught to us in law school. I attended law school with one or two psychologists and actually a physician. And I had a background, as I said, as a psychiatric social worker and in psychology. And the difference with someone with a clinical background in understanding how to evaluate someone and someone who doesn't is it's just a world of difference. Psychosocial evaluations, it's a strategic, it's a systemic tool that provides an in-depth understanding about the client, his world, and issues in a way you can't get in any other format. It allows the lawyer, as I said, to develop strategies. And there's certain areas in particular you look at, including childhood development, stressors, traumas, and challenges. You look at quality of relationships to immediate and extended family members, sometimes called family dynamics. You look at the individual's health, including psychopathology. Psychosocial evaluations also look at the interaction with home, environment, community, in the context of work, education, interest, socialization. A huge part of it is motivation and decision-making, sometimes called psychodynamics. Perceptions of people and issues. We want to understand both objectively what this person's experience was like growing up and so on, but we want to understand the person's subjective perceptions. This is very, very important to understand. There's a situation that objectively may have been very neutral to an outsider looking in, but to your client subjectively, his sense of security was undermined, his sense of stability and safety was jeopardized, so that he went on a pathway that was very destructive or self-destructive. There are different kinds of evaluation tools, and I speak about this in other programs, but there's neuropsychological evaluations, which are usually paper and pencil self-reports. There are psychosexual evaluations, psychological evaluations generally, psychiatric evaluations, social work evaluations. I have a particular bias towards them myself because they are quite holistic in nature. They look at the person's broad psychosocial background for the criminal mitigation report. That could be very, very, very helpful. There are medical evaluations. I always ask clients, when's the last time you've seen a doctor for a general checkup? In theory, the primary care physician should be the case manager for the medical issues for the client and refer the client out wherever needed. It doesn't always happen. And of course, psychodynamic evaluations, which looks at unconscious processes, motivations, and judgment that the client has that they may not be aware of. Many of our clients in earlier developmental stages have suffered trauma. They have not had healthy emotional attachments and physical bonds, and they don't gain a sense of predictability and certainty in their lives, and that's a core area that needs to be understood. Many lawyers are now familiar with ACEs, adverse childhood experiences for criminal mitigation purposes, and it looks at maladaptive risk behaviors that emerge from negative life experiences, including physical abuse, sexual emotional abuse, physical emotional neglect, intimate partner violence, if the client's mother was treated violently, if there's substance abuse or misuse in the household mental illness, parental separation or divorce, and if a household member has been incarcerated. There are many positive factors to consider within the adverse childhood experiences approach. There are also many areas that are missing. I'll give you just one huge one. One is neglect in a fundamental way. I'll hear clients that tell me they've been abused in childhood. The abuse is often predictable and believe it or not, it can actually provide a sense of certainty in the person's life, even though it's obviously traumatic and negative. But I see also clients who've been abandoned. I'll see clients who, their fathers have abandoned them, and they have very little contact when they're growing up. They say, oh, my dad was supposed to pick me up 4 o'clock Friday afternoon after school and spend the weekend together. 4:30 rolls around, 5, 6, 7, 8 o'clock. He doesn't show up. That's abandonment, and that happens repeatedly. It's not captured in abuse. It's not really captured in neglect. The client blames himself. The client assumes that he did something wrong, that there must be something deficient with him as a child for his father to have abandoned him. There's some things that are not really captured in adverse childhood experiences, and a very huge area is education. We want our kids to go to school. We want them to read books. We want them to socialize at school. Education, you can see, is not in adverse childhood experiences criteria. Many of our clients have suffered complex trauma. I have a completely different program on this. Basically, if you're constantly thinking about safety and security, you have no brain power left over to think about curiosity and wonder or focus on school, family, and love. The stress response systems are always activated at a very heightened level with such individuals, and they're focused on survival and not playing and not exploring the world. The survival brain is active and the learning brain is dulled. It creates a value system also. This is very, very important to understand. You see clients who look like, I hate to say it, but psychopaths. Some of these clients, their value system has been harmed because of the complex trauma they suffered as children. They're not psychopaths. They actually can have empathy for people. They can engage in a healthy way, but their value system has been fundamentally undermined. It's important in these kinds of cases to conceptualize harm broadly, to consider all sorts of impacts that may have affected the client's not just psychological well-being, but their daily functioning, their ability to go to school and go to work and care for themselves in a proper way. We want to look at what the client has lost, not just in terms of abuses that occurred because of trauma in the family, but how the client may not have been able to socialize and so on. We also want to get out of the home. This is another problem with the ACEs. We want to look at the community, look at, did this child grow up with violence in the community, drugs, gangs, prostitutions, guns, or other weapons? I had 2 cases the last couple of years. They're very interesting, where 2 people got into trouble later in life. They had no previous criminal history, and they had grown up in families where none of the brothers, this was a family of 6 brothers, got into trouble. They all went to college. They all had families. They all had careers. And it was frankly, a group that they lived in, the greater community, where there was a lot of violence and drugs and just the worst things, and people didn't complete their high school educations. And I asked my client, how is that you and your brothers all completed your educations and none of you got into trouble until now? He wasn't very serious, and you married and you stayed very friendly. And he said something I'll never forget. He said, my parents didn't let us go into the community. The community was violent and there was a lot of drugs. And I said, how did you survive? He said, we went to school, we came back from school. He said, we wanted to take karate, we went to the dojo, we came back. I said, you have all these friends. How do you have friends? He said, my father and mother would say, you want friends? Invite them over for dinner. We'd love to have them. Play games here. Our house is safe, the streets aren't safe. So understanding and removing ourselves from such a strong emphasis on family and home pathology to community trauma and community pathology is very, very important. I want to thank you today for listening. This is an introductory program for criminal mitigation, both for neophyte criminal defense lawyers, but really also, quite frankly, for criminal defense lawyers that have been practicing for years or even decades. I'm a passionate believer that criminal mitigation is absolutely necessary. I think in some cases it's even malpractice when it's not, because there are so many psychological and personal and family issues that need to be uncovered and need to be explained to the criminal defense lawyer, who can then advocate more holistically for the for the client, and obviously at the pre-plea stage and the pre-sentence stage, you want the strongest possible presentation of the client in the best possible light, given who they are as a human being and their failings and traumas and challenges they've had, to ultimately humanize the individual, make them look like a real person, because they are a real person, regardless of what they've done. Please don't hesitate to contact me. Please email me. Put all your information in so I know you're real and not spam. I'll send you back a redacted copy of a criminal mitigation case. And what I hope to do in the following weeks is to present all the other CLE programs that I've done for private providers so that everyone will have them for free. As I said, I've tried to encourage National Association of Criminal Defense Lawyers and other associations in the United States to present these. I've presented a few, actually, and that's wonderful. But I hope this was helpful, and I hope it augments your practice in a positive way. Honestly, it's been an incredible pleasure for me over the last 20 years working with just incredibly experienced and knowledgeable criminal defense lawyers and immigration and civil litigation lawyers who've helped me improve my work as a forensic psychiatric social worker and through my practice in forensics, writing books, giving lectures, and so on. Thank you very much, and I hope this was helpful, and I hope to hear from you in the future.